So the patent agent examination 2022, this is set code C and we are solving paper 1. So in the part 1, it consists of 30 multiple choice questions for 2 marks each. The first question is, Nile Inc. is a global e-commerce major with operations in multiple countries. Nile has filed a patent application in Korea on 1/06/2020. Subsequently, Nile has filed a patent application for the same invention in Canada on 1/5/2021, claiming priority of the Korean application. Finally, Nile filed a convention application in India on 1/11/2021, claiming priority of the Canadian application. The Korean application was published on 2/12/2021. Which of the following statement is true? So A, Nile is entitled to claim priority of the Canadian application and the claims of the Indian application are not anticipated by the publication of Korean application. So this is false. Nile is entitled to claim priority of the Canadian application. The claim of the Indian application are anticipated by publication of Korean application. This is also false. Nile is not entitled to claim priority of the Canadian application. This is true. And the claim of the Indian application are not anticipated by the publication of Korean application. So I think these both are true. And last one we'll read, Nile is not entitled to claim the priority of the Canadian application. This is true. And the claim of the Indian application are anticipated by the publication of Korean application. This is false. So the correct option here is C. The next question is, your client IP India Inc. wishes to file a PCT application claiming priority from an application that they are going to file in India. If they wish to utilize the time limits available under PCT to the fullest extent, how will you organize the following items related to his PCT application in most likely chronological order? So they have given first filing of PCT international application, second filing of priority application in India, third PCT international publication, fourth grant of patent in designated country, and fifth PCT national phase entry in designated country. So here the first number should be in chronological order, filing of the priority application in India. This will be the first. So 2, then second will be filing of PCT international application. So 2, 1. Third will be third PCT international publication. Then PCT national phase entry in designated country. And the last one will be grant of patent in the designated country. So the chronological order will be 2, 1, 3, 5, 4. So the correct option is B, 2, 1, 3, 5, 4. So next question, which of the following is not a ground of pre-grant opposition under section 25(1)? A, that applicant has failed to disclose to the controller the information required by section 8, that the subject of any claim of the complete specification is not an invention, that the claim of the complete specification is not clear, and last one, that the invention so far claimed in any claim of the complete specification is anticipated. So here has failed to disclose to the controller the information required by under section 8. This is a pre-grant opposition ground. Then the subject of any claim of the complete specification, this is also a ground for pre-grant opposition, and the last one is also ground for pre-grant opposition. So the correct option is option C. Next question, which of the following is not a requirement of the complete specification under section 10 of the Act? Fully and particularly describe the invention and its operation or use and the method by which it is to be performed. So this is needed. End with a claim or claims defining the scope of the invention for which protection is claimed. This is also essential. A declaration by inventors that the information given in the specification is true to their knowledge. This can be given later, like after the complete specification. So the correct option is C. Moving towards the next question, question number 5. An application for restoration of a lapsed patent may be filed within dash from the date on which the patent ceased to have effect. So it is clearly 18 months, and this is given in section 60, that is restoration of lapsed patent. Next question, which section of the Patent Act empowers central government to revoke a patent in public interest. So this is section 66, that is revocation of patent in public interest. Question number 7. Patent office is established under which section of the act? So it is given under section 74, that is patent office and its branches. So the correct option here is D. Question number 8. Which of the following is not a ground for making an application for compulsory license? A. The reasonable requirement of the public with respect to the patented invention has not been satisfied. This is a ground. B. The patentee is a company which has gone bankrupt. This is not a ground. C. The patented invention is not available to the public at a reasonably affordable price. This is a ground. And the last one is the patented invention is not worked in the territory of India. So the wrong option here is B. The patentee is a company which has gone bankrupt. So the next question. Which of the following could be minimum fee to be paid for an application for patent filed by an educational institute as on March 2022? So as you know, for e-filing, the fees is 1600. That is for natural person, startup, small entity or educational institute. So the correct option here is B, that is 1600. So the next question is, Prarthi is an inventor for an application for a patent filed by a university. If her name has to appear in the patent certificate, a request has to be made in. So a request has to be made in form 8, that is request or claim regarding mention of inventor as such in a patent. Question number 11. Miss Lakshmi Priya wishes to file a patent application in India, but she came to know some of the invention are not patentable in accordance with the Indian Patent Act. Could you please help her to match list 1 with the list 2 and select correct code? So here section 3L. So actually section 3L is for literary, dramatic, musical works. So here television products. So 3L for television products. 3M, M is for method of playing a game, performing mental act. So this is method of performing a mental act. So M is for C. Section 3N, N is for the presentation of information. And 3O, O is topography of integrated circuits. So the correct order is D, C, A and B. So A is the correct option here. Next question. Time limit under Rule 132 within which an application for setting aside an ex parte order passed by the controller shall be dash from the date of communication of the order. So the rule 132 is application for review of decision and setting aside of order of the controller. So here it is given as 1 month. So the correct option here is A, that is 1 month. Question number 13. Anthony owns a small workshop in Mangalore. He has invented a new coconut grater. He has filed a provisional specification on 1st of June 2021. As the time limit for filing the complete specification is only a fortnight away, Anthony realizes that he needs 4 more months to complete his invention and file a complete specification. Which of the following is appropriate as per the statute advised to Anthony? So here the first option given is the time limit for filing complete specification can be extended by 4 months by filing form 4. So that is not true. Next one is Anthony can file the complete specification after 4 months along with a request to post dating of the application by 4 months. Next is Anthony can allow this application to be abandoned by not filing complete specification and file a new application after 4 months with complete specification. And the last option given is Anthony can file a request for post dating the current application by 4 months immediately and file complete specification within 4 months. So the correct option is D, and this is given in section 9 of the Patent Act. Moving ahead, question number 14. COVID Med Limited wants to manufacture an anti-malaria drug in India solely for exporting to an island nation. Acacia, a Swedish MNC, holds the patent for the drug in India. Which of the following is not a requirement to be met by COVID Med for obtaining a compulsory license for the export of the drug to the island nation? Option 1, that the COVID Med has obtained a compulsory license for the drug in the island nation or by notification allowed the import. That the COVID Med has obtained a compulsory license in India under Section 84. That the island nation do not have sufficient manufacturing facility in the pharmaceutical sector. And last one, that the island nation is using the importation of the drug for addressing their public health problems. So here they have asked which of the following is not a requirement to be met by COVID Med for obtaining a compulsory license. So the correct option here is B, that COVID Med has obtained a compulsory license in India under Section 84. Question number 15. A Danish citizen who is residing in India wishes to file first application at Denmark. Whether A, he has to take permission from Indian Patent Office before filing in Denmark, he has to take permission from Danish Patent Office before filing in Denmark, he has to take permission from Denmark Embassy in India before filing in Denmark, he has to take permission from Indian Embassy in Denmark before filing in Denmark. So the correct option here is A, he has to take permission from the Patent Office India before filing in Denmark. Question number 16. Arrange the following items related to post-grant opposition in the most likely chronological order. Revocation of patent, opposition board formation, filing of post-grant opposition, grant of patent. So, the first chronological order will be grant of patent, that is 4th. Then filing of post-grant opposition, followed by opposition board formation, and then the revocation of patent. So 4, 3, 2, 1. So the correct option here is C. Moving towards the next question, Mr. Daivam would like to know time limits generally available to meet requirements in accordance with the patents law. Match list 1 with list 2 and select the correct answers. Information and undertaking under section 8.1. So statement and undertaking comes under form 3 and the time limit given here is under rule 12, that is 6 months. So this should be 6 months, within 6 months. Reply to first examination report with extension. So the time for putting the application in order is given under rule 24B. So that is 6 months, which is extendable for 3 months, that is 6 plus 3 equals 9. So here it is within 9 months. The next is PCT national phase application. It is done within the 31 months. And the last one is request for examination. So request for examination, this is within 48 months and it is also given in rule 24B, and the form for this is form 18, that is request for examination of application of patent, and the section for examination is section 11B. So the correct order here is 1C, 2D, 3A and 4B. Question number 18. Minimum age limit for a person to be mentioned as an inventor in a patent application shall be A, 18 years, B, 21 years, C, 14 years, D, none of the above. So here it is none of the above. Next question. Controller has which one of the following powers of a civil court? Issue an order to arrest a person in case of infringement with the help of police, order of infringement to the defaulter, examine a person on oath and take evidence on oath, none of the above. So the correct option here is C, examine a person on oath and take evidence on oath. So this is given in section 77, that is a controller to have certain powers of a civil court. Question 21. Radhamani, an IPR student, wishes to know the important case laws on various provisions related to patent in India. Match list 1 and list 2 and select correct code. So compulsory license, the case is Bayer Corporation versus Natco Pharma. Section 3D, it is Novartis versus Union of India. Date of grant of patent is Dr. Snehalita C. Gupta versus Union of India, and infringement is Bajaj Auto Limited versus TVS Motor Company. So the correct option here is B. Next question. Assertion. Patent right is a negative right. Reason. Patentee has exclusive right to prevent third parties who do not have his consent from using his invention. So codes are both A and R are true. R is the correct explanation of A. So this is the correct option. Question number 23. Arrange the following items related to pre-grant opposition procedure under Patent Act in the most likely chronological order. Filing of pre-grant opposition by the way of representation, publication of patent application, applicant filing reply to the pre-grant representation, hearing before the controller. So the first option here should be publication of the patent application, followed by filing of pre-grant opposition, that is followed by the applicant filing reply to the pre-grant representation and hearing before the controller. The correct option is B. Question number 24. Mr. Akhil has already filed his patent application, but he is confused with the applicability of the forms provided. Could you please help him to match list 1 with list 2 and select correct code? Request for publication. So request for publication is form 9. Request for expedited examination, this is under form 18A. Application for amendment of the application of patent, form 13, and request regarding the change in the applicant for patent. For this there is form 6. So the correct option here is B, C, D, B, A. Question number 25. Assertion. Applicant does not have unconditional freedom to file a divisional application. Reason. A divisional application can be filed by applicant only when there is more than one invention in the specification. So the correct option here is A. Both A and R are true, and R is the correct explanation for A. Question number 26. You have filed an application for patent. Claim 1 of the specification recites features A, B, C and D of the invention. Claim 2 is a dependent claim reciting a feature E. Examination report cites document D1 for anticipation, lack of novelty, and has identified A, B, D in D1. Which of the following is most likely to be a response to the examination report? Option A. Amend claim 1 to add feature E of claim 2 into claim 1 to render claim 1 novel. Withdraw application as it is likely to be refused. No. Retain claim 1 as such and point out the controller that D1 do not disclose feature E. Last option is retain claim 1 as such and point out to the controller that D1 do not disclose all the features of claim 1. So I think the correct option is D. Question number 27. Patent shall not be granted before the expiry of dash months from the date of publication of the application under section 11A. So this is given in rule 55, that is opposition to the patent, and the time limit is patent shall not be granted before the expiry of 6 months. So the correct option here is A, that is 6 months. A US citizen is a patentee in India. His patent rights are valid in India, USA, India and USA, all of the above. So it is India. Next question. Meenakshi filed an application accompanied by a provisional specification. She filed a complete specification within 6 months. Claim 1 is partially disclosed in provisional application and partially disclosed in complete specification. The priority date of the claim shall be A. Date of filing of the complete specification, date of filing of the provisional specification. Controller shall decide based on the disclosure of the specification and the content of the claims. As the subject matter of the claim is partially disclosed, the priority date will be considered as between the date of the filing of provisional and complete specification. So the correct option here is A, date of filing of the complete specification. Last question. Nirmala, an Indian scientist working in NASA, files an international patent application PCT with basic application in USA on 30th of Jan 2010. She plans to file national phase application in India. Which of the following is correct? A. She has to file national phase application within 31 months from the basic USA application filing date. B. She has to file national phase application within 48 months. C. She has to file national phase application within 12 months. And D. None of the above. The correct option here is A. She has to file national phase application within 31 months. So here we complete part A of the 2022 paper and we will proceed to part B now. Part B is for 10 marks and consists of 10 true or false type questions for 1 mark each. So each question out of the 4 options, only one option is correct and answer should be given as A, B, C or D. So question number 31. A request for examination under section 11B can be filed by an applicant or any interested person. This is true. If request for examination is filed by interested person, then the first statement of objections FER is issued to the interested person who has filed a request for examination. This is false. So the correct option is A. Statement 1 is true and 2 is false. Question number 32. An application for review of decision shall be filed in Form 24 within 3 months from the date of communication of the decision. This is false because although the application should be filed in Form 24, but the time limit here is wrong. The time limit is within 1 month and that is extendable to another 1 month. So therefore this is false. The second sentence is an application for review of decision shall be filed in Form 23 within 1 month from the date of communication of the decision. This is also false because it is not in Form 23. Form 23 is for application for the restoration of the name in the register of patent agent. So both are false. Therefore the correct option is C. Next, you have filed an application on behalf of a SME client. The distinguishing feature of the invention is a hinge made of aluminium. Controller has cited a prior art for anticipation which teaches all limitations of your claim 1 except that the hinge is taught to be made up of any metals. 1. The claims are anticipated even though aluminium is not specifically disclosed in the prior art. Persons skilled in the art readily recognize aluminium as a metal. This is false. And the second sentence is the claims are not anticipated even though aluminium is readily recognized as a metal by a person skilled in the art. Aluminium has not been specifically disclosed in the prior art. This is true. So the correct option is B. First is false, second is true. Next question. Geeta and Sita are final year BTech students in the College of Engineering, Bhavnagar. They have assigned their invention to ABC Inc. Geeta and Sita can assign the declaration of inventors in Form 1 and ABC can furnish it as a proof of right. True. Second sentence. Geeta and Sita can sign a deed of assignment transferring their rights to apply for patent to ABC and ABC can furnish the assignment deed as a proof of right. This is also true. So both are true. The correct option is D. Next question. A patent agent can appear for hearing before the controller in proceedings related to a patent application. Second sentence. An advocate who is not a patent agent can appear for hearing before the controller in proceedings related to the patent application. Both are true. Therefore, the correct option here is D. Next question. 36. Renewal fees shall not be paid for the patent of addition. This is true. And the second sentence is renewal fees shall not be paid for the patent granted for divisional application. So this is false. So we have to pay the renewal fee for divisional application. So the correct option is A. First is true, second is false. Next question. Patent agent shall file all documents at patent office only by electronic transmission duly authenticated when acting on behalf of multinational companies. This is true. Second sentence. Patent agents may file physical copies of documents at patent office when acting on behalf of applicants who are natural persons. This is false. So correct option is A because we have to file the electronic transmission duly authenticated in the patent office. Next question. Gautam has filed an ordinary application for his invention. Later on, he came to know that he can file PCT international application within 12 months from the date of filing of Indian application. Claiming Indian priority, he has filed a PCT application and he has filed a national phase application in India. 1. Gautam shall make the request for examination for both the applications filed in India. Gautam shall make the request for examination only for one of the applications filed in India. So second one is true, first one is false. So correct option here is B. Next question. A company Covicare Pharma want to change its address of service and also wants to make voluntary technical amendment in the specification of same application. The above two statutory actions shall be completed by A. Filing two forms 13, filing one form 13 and one form 16. So the first sentence here is true and second sentence is false. So the correct option is A. Last question from part B. Barbara, a US citizen, has been residing in India continuously for the past 2 years. She is a scientist at the Global Research Center of an US automobile company in Bangalore. Barbara has invented a novel airbag release mechanism for which her employer wishes to apply for the patent in USA. Her employer does not wish to file any patent application in India as their products are not sold here. Number 1. Barbara and her employer can proceed with the US application without making any request for permission under Section 39 as she is a US citizen working in the US company. So this is false. She has to make a request. And second sentence is Barbara has to make a request for permission to apply for patent outside India under Section 39 before proceeding with the patent application in USA. This is true. So the correct option will be B. First is false, second is true. So here we complete part B and we'll proceed to part C. So part C, there are 10 multiple choice questions and it has 3 marks each, and here more than one option is correct. So the first question here is an application for a patent shall be published under section 11A except in cases where the application A, in which secrecy direction is imposed under section 35, this is correct, has been abandoned under section 9(1), this is also correct, has been withdrawn after the issuance of FER, this is incorrect, and D, has been withdrawn 3 months prior to publication under section 11A. So A, B and D are correct here. Moving to next question. An application for patent has been filed along with filing fee of 1390 rupees. Which of the following could be true about the said application? Application is filed by startup. Yeah, this could be true. Complete specification has 31 pages and 7 claims. So 31 pages, that is 160 rupees extra for one page. So it will not be 1600 plus 160 is not 1930. So it is wrong. Then the next option is complete specification has 24 pages and 11 claims. So for extra claim, they charge 320 rupees extra. So 1600 plus 320 is 1920. So I think this is the correct option here. So option A and C are correct. Next question. Florina is a housewife. She has made modifications on the mopping device which has made her task much easy now. If she were to approach you for applying for a patent, which of the following would be your advice to her as her patent agent? A. Florina's invention is not patentable as it is a modification of an existing device. Florina can file a request for expedited examination if she is the applicant for the invention. This could be correct. Florina, being a woman applicant, is entitled to waiver of application fees. Incorrect. Florina can assign her right to apply for a patent to Home Appliances MNC. This is also correct. So correct options here are B and D. Next question. An applicant may file a request for expedited examination on the following grounds: that India has been indicated as the competent ISA, true; that the applicant is a startup, true; that the applicant is a small entity, true; that the applicant is a department of the government, true. All the options here are correct. Next question. Kavya is a teacher residing in Thrissur, Kerala. She wishes to file an application for patent in physical mode. Which of the following is correct means for her to pay the fees payable as per the Rule 7? In cash at the appropriate patent office, true; in the form of DD, drawn in favor of Controller General of Patent payable at Mumbai; in the form of DD, drawn in favor of the Head Office of Patent Office payable at Chennai; in the form of DD, drawn in favor of Controller of Patent payable at Chennai. So option A and D are correct. Next question, the claim or claims of a complete specification shall relate to a single invention, a group of invention linked so as to form a single inventive concept, shall be clear and succinct, shall be fairly based on the matter disclosed in the specification. So here all the options are correct. Next question, in reliefs in suits for patent infringement under section 108 of the Act, A, the court may grant injunction, court may grant either damages or an account of profits, court may order to arrest the infringer, court may order to forfeit or destroy the infringing goods. So here also A, B and D are correct. Court may order to arrest the infringer, this is incorrect. Next question, who are the persons entitled to apply for patents? Any person claiming to be true and first inventor of the invention, true. Any person being the assignee of the person claiming to be true and first inventor in respect of the right to make such an application, true. Any legal representative of a deceased person who immediately before his death was entitled to make such an application, true. Importer of the invention, this is false. Next question, the patent application can be treated as withdrawn under which of the following circumstances? In the case the applicant or any other interested person do not make a request for examination of the application for patent within the prescribed period as specified, true. Under the condition that the applicant may at any time after filing the application but before the grant of patent withdraw the application by making a request in prescribed manner, this is also true. Response to first examination for the patent application is not filed within the prescribed time, this is false. And pre-grant application has been filed for the patent application, this is also false. So the correct options here are A and B. Last question, Aditya has filed 2 applications for patent with provisional specification. Which of the following conditions ought to be met for the controller to allow Aditya to file one complete specification in respect of the 2 provisional specifications? A, invention of the 2 provisional specifications is cognate or one is the modification of other, this is true. The complete specification shall be filed within 12 months from the date of filing of the last filed provisional specification, no. Inventors for both the applications should be same. And last is the complete specification shall be filed within 12 months from the date of filing of the first provisional specification. So this is also true. The correct options here are A and D. So here we finish the paper 1 of year 2022. The next video will be solving the paper for the year 2018. Thank you.